Good afternoon, students. Today, I want to pick up murder as a topic to start our PYQ series. The whole intention of this series is to simplify and deal with complicated topics quickly, concepts also quickly, so that you are able to answer certain questions which can be situational in nature, direct in nature also. In today's lecture, when we discuss murder, I have kept the discussion limited to the concepts in murder and the kind of questions that can come out of the particular section. We'll deal with a short set of questions related to murder today, and my intention is that this series, with regards to PYQ, starts with this particular topic because it is most often asked to you in your papers. Also, the idea is that these concepts are practically relevant also when dealing with such cases, and also for your papers, those who are aspiring for judiciary. The questions that I have picked up are from Uttarakhand, Delhi, Bihar, so they are relevant holistically. If you see the type of questions that I have chosen, they are similar in nature, and it means that whichever state, or now especially when it is when there is this idea that unified papers may take place, are relevant for you to understand the tonality of questions that can come to you. So without wasting time, we can start with the discussion on murder. I will not directly go to the previous year questions. What I want us to do is first get a basic outline of what murder is, right? I have given the provision in short, which states that, and it starts with that murder, except in the cases hereinafter accepted, culpable homicide is murder, which implies that murder is a form of culpable homicide. And what is culpable homicide? Culpable homicide implies that you are responsible for the death of a human being. And in certain situations, this will become murder. When you look at the situations which are provided below, what we realize is that the essence of murder or liability for murder comes from the mental element that is involved when you commit the act. So when I hit a person with a knife or stab a person with a knife, what mental state am I holding at that particular time is going to define whether it is murder or not, right? So when we look at our PYQs also, it has to be with the prerequisite that you're very clear with what murder entails, what are the mental elements expected along with the act for this particular incident to be considered an act of murder, right? So the first clause states that if the act by which the death is caused is done with the intention of causing death, you must intend to cause the death of the individual. Your act must be with the intent to cause death. If the act by which the death is caused is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused. In this particular section, we see that you must intend to cause a bodily injury. And this bodily injury is something which you know will most likely, or likely is the term used, and we'll refer to that, will cause the death of the person. So here, the intention to cause death is sufficient for murder. Here, the intention to cause a particular bodily injury, for example, if I know that there is a a certain brain injury which a person already has, and it makes that person vulnerable, to die if any kind of small injury is caused to his head also. This is just an example. The point is that here, if you still cause an injury to the head of the person, there we might say you intended to cause such particular bodily injury, and you know that it was likely to cause death of the person. So when I will teach this in BNS, I will take a lot of time in order for us to understand the difference between intention and knowledge, and for us to understand how these degrees change when we are talking about clause A. What are the mental elements expected? What is it when clause B is involved, and so on. Going further to clause C, it states that if the act by which the death is caused is done with the intention of causing bodily injury to any person, and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Right? The previous clause said that you know and you intentionally cause a particular injury to a particular person, likely that it is going to cause the death of the person. This one is different. It's saying you intend to cause an injury to any individual. For example, stabbing a person 15 times. You intend to do that, and that can be to any individual, any person. It is not requiring a specific subjective person and a specific prerequisite, as I gave you the example in the previous class, that the person had a precondition and then I gave an intentional injury. This one is differing. It says that you want to particularly cause intentionally a certain set of injuries or an injury to any individual, which is sufficient in the ordinary course of nature to cause the death of the person. 15 stabs, 20 stabs, we can argue is sufficient in the ordinary course of nature to cause the death of the person. So, intending a bodily injury is again the expectation here, which is sufficient in the ordinary course of nature to cause the death of the person. Now, the fourth one, it states that if the person committing the act by which the death is caused knows that it is so imminently dangerous that it must, in all probability, cause death or such bodily injury as is likely to cause death, and commits such act without any exercise of excuse for incurring the risk of causing death or such injury as aforesaid. In simple term, this doesn't, like the previous clauses, anywhere use the term intention. Rather, it requires only for you to know that what you're doing is so dangerous that it must, in all probability. Now, using the word in all probability means that it is more than just saying that likely, it is likely to be caused, which is the language used previously. In all probability means the most, it is the outcome which is most probable, most expected to take place, and you do it without any excuse of the risk that it might entail and cause the death of the person. So this is the main provision, in short, in context of murder. I have also given us the outline of the exceptions. As stated by me in the start, there are situations in which there may be a circumstance that this act will not come under the ambit of murder. And what are those situations? The first one, culpable homicide is not murder if the offender, whilst deprived of the power of self control. So he's deprived completely of self control by grave and sudden provocation, causes the death of the person who gave the provocation, or causes the death of any other individual by mistake or accident, right? So this case, your first exception where the act is culpable homicide but is not amounting to murder, it is not murder in the case of this exception, is where you are completely deprived of your self control by grave and sudden provocation by another, and this causes death of the person who provokes or by mistake of any other individual. Second one, culpable homicide is not murder if the offender, in the exercise of good faith, in good faith, the right of private defense of person or property exceeds the power given to him by law and causes the death of the person against whom he is exercising such right of defense, only if it is done without premeditation, without any intention of doing more harm than what is necessary. Without intention, you can cause more harm, except that it must be without intending to do the same and without premeditating the same. So, simply put, this exception requires or protects you because you are exercising your right of private defense in good faith. It can be against person or property, but it must be exercised against the individual, or the death must be caused of the person against whom such right has been exercised. It must be without premeditation, and it must be without intending to want to cause more harm than that is necessary. So it must be innocently done. The exceeding of private defense must be, simply put, innocently done. Third exception talks about when the act is being done by a public servant or in the aid of a public servant who is acting for the advancement of public justice. He exceeds or she exceeds the power given to him by law, causes the death of a person, but again it is required that you must do it in good faith, believing, not necessary that it is, believing it to be lawful and necessary for the due discharge of his duty as a public servant, and without having any ill will towards the person whose death is caused. Exception 4 says culpable homicide is not murder if it is committed without premeditation, in a sudden fight, in the heat of passion, upon a sudden quarrel, without the offenders having taken undue advantage or acted in a cruel or unusual manner. Now, exception 4 states that in case you have had a quarrel which results in a fight, and in the heat of passion there is a death that takes place, as long as it is without premeditation, without taking undue advantage or acting in a cruel or unusual manner, the exception can be applied to, right? The explanation I have mentioned here, it is immaterial in such cases which party offers provocation or commits the first assault. This is for exception 4. We will get into depth when we discuss our questions in this particular aspect of exception 4. Quickly now going to exception 5, it simply states that culpable homicide is not murder when the person whose death is caused, being above the age of 18 years, suffers death or takes the risk of death with his own consent. So, where a person is giving consent to the particular act and takes the risk of death as an outcome of the act, in such a situation exception 5 is applicable. So I just wanted to start off by giving an outline of what murder and its exceptions are. Repeating myself, murder, you either intend to cause death, intend to cause a particular injury, knowing by such injury it is likely to cause the death of the person harmed. Third one, again you intend a bodily injury which is sufficient in the ordinary course of nature to cause death of a person. Fourthly, now here intention is not a term, but you know that what you are doing is so imminently dangerous that it must, in all probability, cause death or such bodily injury as is likely to cause death. It is such an act that it is most likely to cause death, in all probability to cause death. Then, if it is done without excuse for incurring such risk, it could amount to murder. The example that this particular provision has is in regards to where a person starts firing in a crowded area. And this is an easy example of the fact that you know what you're doing is so dangerous, and yet you have no excuse for the risk that you are incurring. It can amount to murder. You may argue that you didn't intend to cause any death, but here intention is not required. Simply knowing that it could have this outcome will make you liable. And as we discussed exceptions, the first one is in context of grave and sudden provocation given to you, and therefore you commit an act which has caused the death of the person, is covered under exception 1. Exception 2, you have exceeded your right of private defense innocently, the protection is given to you. Exception 3, public servant or anyone aiding a public servant exceeds his rights or his duties, believing that he is lawfully discharging his duties. If it is without ill will, such person is protected, or it comes under the exception 3. Exception 4 in is in relation to where there is a sudden fight, and in heat of passion without premeditation you have caused the death of a person. Lastly, where you consent to an act, consent to the risk involved, and where it causes death, is covered under the exception. So with this outline, we now take our first question. The first question which has been asked is, A, with the intention of causing death, intending to cause death of Z, commits an act which is give him a severe blow on his head, and Z became unconscious. A, believing Z to be dead and with a view to conceal the evidence, throws Z into a pond. It was found that Z died of drowning. Now, in this particular case, you must look at the language that is used. The first half says that the intention to cause death was there. So, the first clause that we had discussed, the mental element is already there. However, the act has not resulted in the death of the individual. But an extension of this full incident was the fact that he wanted to dispose of the body of the individual and believing that body to be dead. And the act that he is doing in order to dispose of the body, if we read the first clause and the last clause, which is that the person knows that what he is doing is so dangerous, which is throwing the body of an unconscious person into a pond, in all probability also, if you look at that argument, is something which can cause such injury or can cause death of the person. What we are trying to imply is that this whole set of circumstances is such where the mental elements which have been provided for us under the section or the provision for murder are fulfilled. Even here, whatever act has been done, There may not have been at this point an intention, but there is a knowledge that the act that they are doing is of such nature which could cause death. And even if there is no there is this idea that you know that what you're doing, throwing of a person in a pond, is of such nature that it will, if the person survives, will cause death of the person. It is an act of wanting to completely annihilate the individual. Therefore the answer to the question is B. Right. Now coming to your second question. A, with the intent of causing mischief of B, on B, set fire to his house. Unknown to A, X was sleeping in the house at the time of X. At the time, X narrowly escapes the fire and suffers serious burn injuries and suffers and is hospitalized for 3 weeks. A did not have enmity against X and displayed remorse for the fact that X got hurt. Which of the following is true? Now, this case or this question differs from the first question in the context of A here has intended to commit a mischief on the house of B. He sets it on fire, and in that particular situation, there is a person sleeping inside the house. This person escapes the house with injuries, right? He does not die but escapes while the house burns. Now look at the options that are given to us. Has A voluntarily committed attempt to murder and grievous hurt? The term is voluntarily. Have you willingly done it? A has, second option, A has involuntarily committed attempt to murder and grievous hurt of X, which is that he didn't want to, but he has. Next question, A has not committed any offense as there was no mens rea and A was remorseful. Now, this one is saying because no mental element which is expected is present, he is not liable. And lastly, A has voluntarily committed attempt to murder but has not committed grievous hurt. Now, the answer to the question given is that it is voluntarily committing of attempt to murder and grievous hurt. In context of this factor, because we are dealing with this topic, let us discuss why this part is coming to the concept of attempt to murder. Attempt means where the act was not fulfilled, but because of certain intervening circumstances, one can say. However, all other prerequisites or elements in simple language were present. Now, coming to our set of requirements for murder, let us go back. Has he got the intention to cause death? No. Did he intend to cause a particular injury which he felt would cause the death of the person? No. Did he intend to cause a bodily injury to any person, and and the bodily injury intended would sufficiently cause death of the person in ordinary course? No. But did he, or can we say that in such circumstance, when you burn a house, did you know that you were doing an act which is so imminently dangerous, because a house is a place where a person may be living, a person can be present, right? And you know that this could be a situation where the death of an individual can take place in all probability, right? Now, when you look at this question again in the background of the fourth option, one realizes that this could be a situation of attempt to murder, because when you are wanting to burn a house, you know that the act is so imminently dangerous, and you are doing it with the fact that there may be a person inside, and in all probability that can cause harm to the individual, which can lead to the death of the person. So you have no, there is no excuse in such circumstances where you're burning a house where it's probable a person is living and can be harmed by the act that you are committing. So, therefore, one thing is for sure, that attempt to murder is a part of this particular act. And the fact that you did it in such situations implies that you took the risk, you knew what you're getting into, and continued to commit the act, which invariably led to harming another person. Now, your third question is in relation to exception 4 of section 300 of IPC. The question asked to you was whether under which of the following situations exception 4 will be applicable. The offender should commit the first assault. Second question, the first assault should be from the deceased. Third option, the first assault may be by a third person. And the fourth option given is that the first assault may be either by the offender or by the deceased. And at this point, it is important for us to discuss the difference between exception 4 and exception 1. Exception 4 states that culpable homicide is not murder if it is committed without premeditation upon a sudden fight, in the heat of passion, upon a sudden quarrel, without the offenders having taken undue advantage or act in a cruel or unusual manner. When it is a fight, which is the term used, both parties are involved in the fight. Unlike what has been asked to you in this question, when you say that this exception is applicable to a person involved in a fight, then it doesn't matter who was the person who started the fight. Either of the person could have been the one who gave the first assault. And this has been reiterated to us in the explanation. In this case, the exception is applicable to either party. It is immaterial who provokes the situation or commits the first assault. Now, why is this relevant? Because it differs from exception 1. Exception 1 states that you can get under the ambit of exception 1 only if you have been provoked and your response is on the provocation of another. So here the first assault has to be from the aggressor, from the opposite party. And because he has provoked you, that has resulted in a response from you. There has been some initiation from the person, there has been some act which has deprived you from your self control, which has resulted in the act on your behalf. And therefore, in order to confuse you, this kind of question may be asked. Remember, exception 1 is where the provocation must come from the opposite party and you respond being deprived of self control to such provocation. Exception 4, on the other hand, is a situation where a fight is taking place and in a heat of passion, you commit an act. So, in this scenario, exception 4 is applicable to either of the parties if they cause death in the heat of passion, and of course fulfilling all other ingredients which are required. Therefore, under exception 4 of section 300 of IPC, the first assault may be from either person because it is in relation to a fight. There is no prerequisite which has to be fulfilled. It is not necessary that the offender should commit the first assault. It is not necessary that the first assault should be from the deceased. The first assault should not be in relation to a third person. It can be from either of the parties who were involved in the fight. What is necessary is that there was a quarrel and then which led to a fight, and in a heat of passion either of the parties has caused the death of another. So that this is the most appropriate response to the question. Your fourth question is, X deliberately tried to shoot a fleeing man who criticized him in a school meeting. Unfortunately, his uncle came in between him and the fleeing man and thus got killed. What offense, if any, has been committed by X? Now let us understand the question again. X wants to shoot a man who's fleeing from the school. Instead, his uncle comes between him and he's shot and gets killed. The intention to kill is there, or to cause an injury is there. That act of shooting also has taken place, right? The only problem is, instead of the fleeing person, it is the uncle who has been shot. The question is, since the mental element as well as the act as well as the outcome of death is there, does the liability of X remain the same? Now, before giving the answer to the question, we must look at an important provision, which is culpable homicide by causing death of person other than the person whose death was intended. Now, it states that if a person, by doing anything which he intends or knows to be likely to cause death, commits culpable homicide by causing death of any person whose death he neither intends nor knows himself to be likely to cause, the culpable homicide committed by the offender is of the description of which it would have been if he had caused the death of the person whose death he had intended or knew himself to be likely to cause. So, what we are trying to imply from this is that in such a situation where the mental state or the mental element is the same, the act which is done is the same. The only problem that has occurred that instead of the person who was targeted, another comes into picture. The section we read told us liability remains the same. The description, the status, the outcome in context of this remains the same, right? So, I hope this is clear to you, students. The fact that he deliberately shot hints at the fact that there was an intent to kill, there was an intent to cause an injury, and shooting in itself being such an act, being the act that was done, was hinting at the fact that the person intended to cause death of the person. Therefore, the most suitable answer to the question is that he should be liable for murder. Okay. Now, this is our last question for today. And the simple question is, A denied food to his wife B for several days by keeping her confined in a room with intent to accelerate her death. B anyhow managed to escape. What offense has A committed? Now, one more thing that I um, wanted to state here is that please note the tonality of the question. Most often, answers are in the question. The words used imply, and there is a reason they have been used, and they hint at the answer which is expected from you. Intention, death. A denied food to his wife for several days by keeping her confined in a room with the intent to cause her death. And however, B has escaped. So the death does not take place. However, the mental elements required for murder are present, as we can see from the question. We can state that the person tried to attempt the murder of his wife since she escaped, and the outcome of death or the causation of death didn't take place, but the elements required were present, and therefore it will be considered an act of attempt to murder. Students, when we cover these topics in our classes in BNS, we go into great depth while dealing with each topic, subtopic, exception, clause. Most of these questions are based on cases which we discuss again in depth so that you become comfortable in giving such answers. Many of these questions are also asked in your mains, and we also explain and mentor you into how answering most suitably this question and comfortably for you this question will result in best scoring for such answers. So I hope you liked this session. We will continue with this same session with similar topics and questions throughout this month, and I hope you enjoyed the session. In case of any questions, queries, I'll be happy to take them up. Any topics that you would like to suggest for future series also, I'll be happy to address. Thank you so much, students. Keep studying and have a great day today. Thank you.